Greetings and welcome once again to Registration of Land Titles, the Torrens title system from American Jurisprudence. Second here. All right. We'll have Black's Law Dictionary, 9th edition at our side to make sure we leave no word behind. With that said, let's get right down to it. Oops. There we go. All right. And please make sure you hit the like so that everyone knows that we're here and the stream has started. Not too sure how many people are in here right now, but that'll help get the word out. That being said, let's get started. So this comes from the 66 AmJur 2nd edition, Registration of Land Titles, and we're going to go over the summary now. The scope. This article discusses the law and procedure relating to legislation by which land titles are registered, commonly known as Torrens Acts. So Sir Torrens was in charge of administrating land titles in South Australia in 1858. And those, that system of titling land carried over to our Transfer of Land Act of 1958, 100 years later, here on America. But we'll get into the details now. Covered within this article are the purpose and effect of such legislation, the types of interest subject to registration, the constitutionality and construction of the Torrens Acts, and potential liability of a land registrar. Also covered is the practice and procedure associated with registering the title to one's land, including the notice required, the trial, and the decree and certificate of title. Collateral attack on registration decrees, the effect of fraudulent registrations, and the remedies for improper registration are also treated herein. Treated elsewhere are abstracts of land titles, adverse possession, liability for issuance of defective certificates, recording of deeds, mortgages, and other instruments of title, and recording of forged deed. So we went over some of these topics in other AmJur live streams, and you can find those on the AmJur playlist on this channel. So let's get right down to it here in section 1. Definition and purposes of land registration, the Torrens title system. The Torrens title system is a system for the registration of land, under which, upon a landowner's application, the court may, after appropriate proceedings, direct the issuance of a certificate of title. The owners of registered land are issued a certificate of title that contains a description of the registered parcel, along with memorials noting all liens, encumbrances, and charges that bind the land. So, as we see here, it's a certificate of title, right, upon a landowner's application. So here's an observation. A parcel of land can be either Torrens or abstract. The necessity of registration to create an interest in the land is what distinguishes registered or Torrens property from abstract property. Unlike the abstract system of property registration, where evidences of title are recorded and the burden is on the interested persons to ascertain the true state of title for themselves, under the Torrens system of property registration, there is a judicial proceeding whereby title itself is registered. That is, under the Torrens system, a party seeking to register an ownership interest in property applies for a court adjudication of ownership and a court decree that converts abstract property into Torrens property. The act of filing and registration are critical in the Torrens system. So those are some interesting observations here we can take away with here about the difference between abstract and a Torrens property. The purpose of the land registration system. Now here's our purpose for going through the trouble. Why would you want to register and use this Torrens system? Was to conclusively establish title to land through the issuance of a certificate of title. See, we're establishing the title through an issuance of a certificate of title. More specifically, the purpose of the Torrens system is to secure, by a decree of court or other similar proceedings, a title impregnable against attack, to make a permanent and complete record of the exact status of the title, with the certificate of registration showing, at a glance, all liens, encumbrances, and claims against the title, and to protect the registered owner against all claims or demands not noted on the book for the registration of titles. Once a proceeding has been held to register land, the certificate of title is conclusive proof of ownership and cannot be altered except as authorized by the Torrens Act. Under the Torrens system, concepts of notice and perfection are accomplished, not by recording, but through notation of encumbrances or interest against real property by a county recorder on a registered land certificate of title. Landowners may remove encumbrances from their property once the underlying debts are satisfied. The certificate of title thus provides a means for determining the state of the title through the inspection of a single document. So, as we see here, the certificate of title provides a means for determining the state of the actual title through the inspection of a single document. So a certificate of title has more than just the ownership. It also has any of the encumbrances of the property, underlying debts, other things like that are going to be seen at a glance on that certificate of title. Of course, nothing here is to be determined for used for utilized legal, lawful, personal, private, or business affairs for your life. This is only for entertainment, educational broadcasts. Don't do this at home. All right, let's proceed here. So the certificate of title thus provides a means for determining the state of the title through the inspection of a single document, rather than examining extensive abstracts of title. Anyone dealing with registered land, such as a buyer, need look no further than the certificate of title for any transactions that might affect the land, because that document describes all ownership interests. So it describes all ownership interests. However, there are exceptions to this general rule. The following interests may not be covered in the certificate of title. Here we go. These are not covered in the certificate of title. Liens under federal law, tax liens and assessments, short-term leases, public highways, pending Torrens appeals, Rights of any person in possession under deed or contract for deed from the owner of a title of certificate. Certain liens or judgments for non-payment of taxes. Exceptions to the statutory requirement for notation or memorialization of all encumbrances as set forth in the Torrens statute may apply only to those estates, encumbrances, and rights that exist at the time of the original registration of the title. The fundamental intent of title registration statutes is to make the status of the title certain, indefeasible, and readily ascertainable. The intention of the Torrens system is to compel every person receiving conveyances of real property to place such an instrument of record. Thus, the Torrens system gives constructive notice to purchasers and encumbrancers who acquire or seek to acquire some interest or right in property. Wow. So here's our observation, and this pretty much sums it up for us. Land registration is designed to provide notice to bona fide purchasers, not to notify owners of encumbrances against their land. So the land registration isn't intended to notify the owner. It's designed to provide notice to bona fide purchasers. The Torrens system is intended to enable a person to ascertain in whom title to property is vested and the encumbrances to which it is subject by simply inspecting the register, and both the certificate of the title and the duplicate certificate are conclusive evidence up to the time of issuance that the title to the property is as stated therein. So both the certificate of title and the duplicate certificate are conclusive evidence up to the time of issuance that the title to the property is as stated therein. Similarly, the registration of a land title under a Torrens system creates an absolute presumption that the Register of Titles speaks the last word about the title to the land, eliminating all secret liens and hidden equities, and making the language in the Register of Titles absolute proof of an indefeasible title, except for the encumbrances and claims noted therein. Thus, one who takes a certificate of title to registered land for value and in good faith holds the land free from all encumbrances except those noted on the certificate and those enumerated in statute. However, knowledge of an unregistered encumbrance does not disqualify the holder of certificate of title from protection afforded him or her by a title registration statute. So that's interesting there too. Having knowledge of an encumbrance that was unregistered, oh boy, does not disqualify the holder of the certificate of title from protection. That's good for the holder of the owner, right? Afforded him or her by a title registration statute. So just the knowledge of an encumbrance does not disqualify the holder as long as it's unregistered. So not everything moral is legal, right? Fundamental to the law of registry is the principle of establishing priority of title. The purpose of registration of title to real property is to quiet the title in the land in order to ensure its marketability. And the purpose here sums it up again. This is fundamental to the law of registry, and it's a principle. The principles prove. They don't need to be proven. and is of establishing the priority of the title. The purpose of the registration of title to real property, right, that's your land, is to quiet the title in the land in order to ensure its marketability. So to quiet the title, to ensure there's no encumbrances or anything like that that would prohibit the conveyance of the land. So as to protect the transferee of a registered title, right? This is the buyer here, suppose in one case, and to simplify conveyancing by allowing prospective purchasers to rely on the certificate of title as reflecting all interests in the land. So no surprises. Torrens Acts give protection to those who purchase property in good faith for valuable consideration and who first record their interests. Torrens Acts protect recorded titles against the gross negligence of those who fail to record their interests in real property. So it works both ways. Caution: a purchaser of Torrens property who has actual knowledge of a prior unregistered interest in the property is not a good faith purchaser. However, if it's the one that's selling it and has knowledge of it and it's unregistered encumbrance or an unregistered interest, it does not disqualify the holder from protection. So the actual knowledge affects a purchaser, but not necessarily the holder. Interesting. That's a very important caution involving the Torrens Act. And what do we get here? It's the constitutionality of Torrens statutes generally, see Section 8. It's actual constructive notice, see Section 3. It's the procedures for obtaining a certificate of title, 11 to 22. So let's continue down here. Let's read this one here. Kentucky law provides a system by which, among other things, mortgage owners preserve priority. All right, let's move to the next one here, Section 2. Effective registration on transfer, sale, or other disposition or acquisition of registered land. Registered land, once originally registered, can be conveyed only by a subsequent registration. Thus, under a statute governing voluntary dealings with registered lands, any unregistered instrument purporting to convey or affect registered land does not bind or affect the land, but is regarded only as a contract between the parties. For example, with respect to land registered with the land court, a bill of sale, though recorded with the Bureau of Conveyances, does not operate as a conveyance to a grantee where the document was never registered in accordance with the land court registration statute. A state Torrens Act may control essentially all dealings with registered lands, such as the transfer of registered property by deed, judicial proceeding, tax sale, tax, or other foreclosure, the law of descent, mortgage, lease, for a charge. For instance, where a state's Torrens Act did not specifically exclude federal sales tax from the type of tax sale that is subject to notice and registration requirements of the Act, a tax sale purchaser's failure to comply with the Torrens Act released the property from the effect of the tax sale and precluded the purchaser from obtaining title. A mortgage is a conveyance of real estate for purposes of a state's Torrens Act. Because only the act of registration creates an interest in a Torrens property, a forfeiture claimant mortgagee has no legal interest in the property before it registers its mortgage. That's interesting here. because only the act of registration creates an interest in a Torrens property. A forfeiture claimant mortgagee has no legal interest in the property before it registers its mortgage. Where registered property is held as an estate by the entireties, a surviving spouse need not comply with the requirements of statutes setting forth the procedure to be followed in transferring the registration of the property upon death of the registered owner, because those statutes only apply to property that is part of the descendant's estate. Once a county has implemented a land partial identifier number, so once a county has implemented a land partial identifier number, a PIN, index that complies with the statutory requirements of a state Torrens Act, such a PIN index is the only index that the county is required by statute to maintain, and an instrument must be properly indexed in this PIN index in order to be registered. Wow. So we have to have an instrument properly indexed in the PIN index in order to be registered. So this PIN index here, the partial identifier number, and there'll be statutory requirements for every state within their Torrens Acts statutes. Remember, there are going to be statutes in every state that comply or harmonize with the Torrens Act. And it's the only index that the county is required by statute to maintain. And an instrument must be properly indexed. Index means pointing to this instrument, which would be the title. All right, let's continue. See, where real property is held by husband and wife as estate by the entireties, at the death of one spouse, the entire property automatically vests in surviving spouse by operation of law. Property does not become part of the descendant's estate. That's Cuyahoga County, Ohio. All right. We got finally some other people filed in here. We have El Perro. I have to read this one out here. Give me a second. The recorded interest on a special warranty deed proves a purchaser is the one with interest as registered versus unregistered. The special warranty is a specific admission of no prior title. So yes, we're going to get into some of these special details later on this one here too, and we also had another stream on the deeds. But indeed, let's continue here. So the effect of registration on transfer, sale, or other disposition of registered land. Actual and constructive notice, so being sent by the court. Under a land registration or Torrens system, the concept of notice is accomplished not by recording, but through notation of encumbrances or interest against real property by a county recorder on a registered land certificate of title. Notice of title given by registry is presumed to be certain, and courts will not allow it to be overridden by equivocal evidence of unrecorded change in ownership. A technical defect in processing documents may not constitute a failure of notice. So just a technical defect in processing is not going to be their failure of notice. So again, the law lies more in the intent, not necessarily the fact for the crime. The Torrens Act gives constructive notice to purchasers and encumbrances who acquire or seek to acquire some interest or right in property. However, a purchaser is charged with constructive notice of only those matters of record in the purchaser's chain of title referred to or about which the purchaser is placed on inquiry. Thus, registration of land protects bona fide purchasers from unregistered interests, unless a certificate of title contains facts that would prompt a further investigation of the registration system. For example, if an easement is not expressly described on a certificate of title, an owner, in limited situations, may take the property subject to an easement at the time of purchase if there are facts described on the certificate of title that would prompt a reasonable purchaser to investigate further other certificates of title, documents, or plans in the registration system, or if review of land court plan would have put landowners on notice that adjoining landowners' lots rely on a private way for access to a public way. So, if you see an easement, you think it's part of the land, you're not sure, you check other plots there, see if there's other records within the registration system making claim to that easement, and is there other landowners that were relying on that easement to access a public way. You would put them on notice through, review of land court plan would have put landowners on notice, so you'd look for those things. You do your due diligence. Some authority states, however, that because the effectiveness of a Torrens system rests on a purchaser's ability to trust the certificate of title to reveal all competing interests, right? That's what they said is supposed to be perfected. The Torrens Act abrogates the doctrine of constructive notice. Caution. The registration of an improperly acknowledged or defectively probated deed imports no constructive notice, and the deed will be treated as if unregistered. So there it is. Regardless of the rule as to constructive notice, a Torrens system of property registration does not do away with the effect of actual notice. A purchaser of Torrens property who has actual knowledge of a prior unregistered interest in the property is not protected as a good faith purchaser. Yes, the purchaser. That is, a landowner with actual notice of a valid encumbrance existing before land registration proceeding is bound by the notice, even if the encumbrance is not unambiguously set forth in the registration certificate. So, if the landowner knows about it before registering the land, then they're not going to be as protected. But the mere registration of an instrument affecting the title to registered land does not impute actual notice to an owner or purchaser of Torrens property. Rather, actual notice requires actual knowledge, and a party must actually know that an interest in the land exists. For example, there must be actual knowledge of prior documents, registered or unregistered, that create an easement over a disputed parcel. Thus, an owner of a registered lot had no actual notice of an easement, as opposed to a merely permissive use of the land. That would defeat the owner's status as holder of the certificate of title in registered land, who took title for the value and in good faith, where there was no reference to an easement in either the chain of title of the lot or outside it. And we have a reference to that case, it looks like here, number 16. Wait, where'd that go? There we go. Calci versus Reitano, Massachusetts Appeal, 2006. Let's see what we have here. Another Massachusetts, applying Massachusetts law. Torrens Acts have not abolished the equity rule that where there are circumstances that, in the exercise of common reason and prudence, should put a purchaser upon particular inquiry, the purchaser will be charged with notice of every fact that an inquiry, if made, would have given the purchaser. So again, the intent of this is to prevent any kind of deceit, knowing deceit, prior to any of the registration process especially. All right, let's go to section 4 here. Effective registration on transfer, sale, or other disposition or acquisition of registered land. adverse possession. All right, in some jurisdictions, under a Torrens system of land registration, no title to registered land can be acquired by prescription or by adverse possession. We went over adverse possession in another one. Adverse possession is land seized over time. It's a belligerent takeover done in wrong but made right in law and legally through the title of actually maintaining, improving, developing, and occupying and defending that land over time, so that there's it's also been made public, so that if there was a legal claim title to that land, that the owner would be aware of it. It's been notoriously posted, and enough time has gone by, so statutorily it should no longer have a claim, and then a so-called color of title could ripen into a legal title. But what we're getting here is in some jurisdictions, under a Torrens system of land registration, no title to registered land can be acquired by prescription or by adverse possession. Under a provision in a state Torrens Act that specifically disallows acquisition by adverse possession, statutory dedication of a roadway under state law is a form of adverse possession, and therefore may not be applied to Torrens properties. Wow. The failure of a registrar to affix the filing stamp to the original plat document does not deprive the owner of the adjoining property from receiving notice that the property was registered, and thus the owner of adjoining property cannot adversely possess a portion of the registered property because the required information is memorialized and made part of the certificate of title. While the filing of a complaint seeking registration of land does not affect the state of the title, it immediately interrupts claims of adverse possession. In jurisdictions with a statute providing for a 30-year recording requirement, a person who claims ownership rights as the result of an event loses the right to bring a claim based on that event, if an instrument or notice of claim is not recorded within 30 years of the event. However, under an owner in possession exception to the 30-year recording requirement, adverse claimants to a disputed strip of land are not required to record a title within 30 years of ripening of adverse possession to preserve the claim where the claimants are owners in possession. All right, let's bring that together with the observation. That way I won't have to further elaborate on that. A title already acquired by adverse possession may be registered because, for purposes of registration, a title by adverse possession cannot be distinguished from a title by grant. However, the title acquired by adverse possession is not a record title unless it is made so. It's not a record title, right? That's a color of title. Interesting. All right, and now we're going to section 5 here, the interest in land subject to registration. Generally, the integrity of land registration laws requires that all estates, encumbrances, and rights be noted on the Register of Titles before they can be recognized and enforced. Titles not recorded in the Office of Registrar of Deeds may be registered. Encumbrances may also be registered. But in order to provide full notice of an encumbrance from the face of a certificate, the encumbrance must be separately and clearly noted thereon, so that the certificate shows all encumbrances at a glance, as we read before. So here's another observation. A certificate of title cannot reflect an encumbrance greater than that which the mortgage deed provides. A memorial noted on the certificate of title to registered land noting the existence of a lien or charge is accurate for purposes of statutes governing encumbrances on registered land, so long as it is properly identified. An example, mortgage, easement, and the like. And the location of the recorded underlying document is correctly set forth, so that a party may determine the extent of the lien or charge. So there's our observation there, that the important part of some of this stuff here involving the Torrens Act is that they have to reflect the reality of, the encumbrances can't be greater than the value that's provided. Memorial noted on the certificate to the registered land noting the existence is accurate for purposes of statutes governing the encumbrances, right? So long as it's properly identified. Interesting. So I guess identifying the encumbrance makes it accurate. In order to effect registered land as a servient estate, an easement must appear on the certificate of title, regardless of whether that easement was granted by deed or acquired by prescription. Similarly, an easement that arises by implication of law after registration of title under the Torrens system will not be recognized and enforced against the alleged servient estate if the implied easement is not noted or memorialized on the Register of Titles. However, where an easement that arose by implication of law came into existence at the moment of severance and the registration, and which ripened for a subsequent period of 10 years, but that was not noted in the certificate of title, such easement was not barred by the Torrens Act. The easement arose by implication of law, came into existence at the moment of severance and registration. Wow, which ripened for a subsequent period of 10 years, but that was not noted. Such easement was not barred. Wow. While ordinarily the owner of the fee simple estate is the one authorized to obtain registration of title, the rights of owners of lesser estates are generally recognized and protected by statements or memoranda upon the certificate of the owner in fee simple, and separate certificates are unnecessary. Under statutes providing that no estate less than a fee simple may be registered unless the fee simple is first registered, life estates have been held entitled to registration after the fee has been registered. However, under other statutes, life estates cannot be registered. Other interests in land may be affected by the registration system. For example, trust, or a document creating a trust, the corpus of which is the land, can be registered so that constructive notice of the terms of the trust concerning the land is provided to every person claiming under a conveyance, attachment, or execution after the trust instrument is recorded in the registry of deeds. So let's see here. Constructive notice of terms of the trust concerning the land is going to be recorded there, right? The title vested in a receiver can be registered. These are different interests in lands that may be affected by the registration system. Tax titles may be registered, but may require conditions precedent to be fulfilled. Leasehold estates, so that the ordinary effect of failure to register a leasehold interest in property registered under the land court system is that every subsequent good faith purchaser who takes a certificate of title for value holds the registered property free from the unregistered leasehold interest. In addition, the law of registry is inapplicable where the ownership of or claiming affecting immovable property has been acquired by inheritance and title has become vested by operation of law. Title to property acquired by inheritance does not require recordation to be effective against third persons. Let's look at this observation. Where the ownership of property is currently in dispute, the land at issue cannot be registered in order to resolve the dispute, such as where neither the grantee under a deed nor the leasee, who has taken possession under a lease prior to the execution of a deed, has registered their competing interest in the land, and where neither has relied or had relied on the register, the grantee's registration of the deed during the pendency, the grantee's registration of the deed during the pendency of the leasee's suit over the land did not defeat the leasee's claim to an interest in it. All right, let's see what we got in the footnotes here. Like how they write Hawaii law. All right. Nothing but the citations of the cases. Section 6. Interest in land subject to registration as applied to multiple housing developments. The leasehold of a member of a residential housing community was considered to be registered by virtue of its memorialization on the certificate of title to the land held by the owner of the community that has owned it as a fee simple estate. Wow. Certificates of title issued by the Torrens office naming as trustee of a land trust as the fee simple title holder to 180 individual condominium units with memorials reflecting the registration of declarations of condominium ownership, the registration of plats of survey, and filing of deeds to 100 units previously conveyed by the trustee were sufficient to establish that the trustee held fee simple title to 80 of the unconveyed units. Wow. Interesting one there. All right, Section 7, Construction of Land Title Registration Statutes. Generally, a Torrens Act must be construed in accordance with the established law of property. Some jurisdictions state that a Torrens Act must be strictly construed. Strict construction is required because the Torrens Act provides for both a system of land registration and remedies that were unknown at common law. In contrast, other jurisdictions state that because land title registration legislation is remedial in nature, it has to be liberally and reasonably construed to effectuate its purpose and intent. This is pretty profound here. Some jurisdictions state that a Torrens Act must be strictly construed. That's the strict construction is required because the Torrens Act provides for both a system of land registration and remedies that were unknown at common law. So they need strict construction of that. In contrast, other jurisdictions state that because land title registration legislation is remedial in nature, it has to be liberally and reasonably construed to effectuate its purpose and intent. They're saying that the registration is only remedial in nature. Moreover, where a Torrens Act is an essential part of a legislative scheme intended to ensure titles to real property are secure and marketable, a court will give full effect to Torrens Act absent the clearest expression of contrary legislative intent. As with legislation generally, land title registration statutes must be construed as a whole, and undue emphasis must not be placed on individual sections thereof. So here's our observation. It has been noted that recording statutes should be construed together as statutes in pari materia. Okay, purpose of recording instruments of conveyance is to impart constructive notice to subsequent purchasers or mortgagees. Unrecorded deeds are effective for parties to deed. As to construction of recording statutes. Okay, that's on section 41 of Records and Recording Laws. And now we're on to section 8, constitutionality of land registration statutes. All right, statutes setting out a Torrens system for registration of land titles have been challenged on a variety of constitutional grounds, but are generally upheld. Examples of unsuccessful constitutional challenges include due process, holding that although Torrens Acts are designed to eliminate attacks on decrees of confirmation, challenges to decrees based on alleged constitutional deficiencies of notice are not foreclosed. And if successful, they do not void the decree for all purposes, but only in relation to the person denied adequate notice. Due process, such as a taking of property without the provision of due process of law. Due process based on a lack of notice provided by publishing notice of the proceeding as to unknown claimants. Taking without compensation, so although a state constitution may permit the state and individual counties to adopt laws providing for registration of land titles, such a provision does not necessarily require that a land registration system be utilized, and the repeal of such system does violate the takings clause. Okay, so the separation of powers doctrine, based on the allegations that the statute vests in the registrar the power to adjudicate, but this argument generally fails because the registrar's decision is not final. So there are remedies, remember, that must be strictly upheld because it's not found in common law. So there we go. The constitutionality looks like it's going to hold up pretty well. And we're on to section 9, liability of land registrar, assurance funds. A registrar of titles may be liable for damages and omissions. Some title registration acts provide for an assurance fund, whereby an applicant for a new land registration must pay into a fund for the possible future indemnity of those who may lose their property through fraud or error, or who could be without other means of redress. A Torrens Act assurance fund provision permits recovery against the fund generally by a person who, without negligence on his or her part, sustains loss or damage in consequence of any error, mistake, or misdescription in any certification of title. However, where an adjoining landowner lost their claim to Torrens registered property in a dispute, and then sought to obtain compensation from a general fund under a statute that authorizes compensation from a general fund to one who is precluded from bringing an action for recovery of property due to a registrar's mistake. The landowner could not obtain compensation from the general fund because the statute does not apply to the losing party in a suit to recover property, and the claimant had a full and fair chance to litigate and appeal their claim to their claimed right to the property. It has been stated that an assurance fund under the Torrens Act is similar in effect to an insurance contract between a certificate holder and the state as a holder of a certain fund. So it seems in that case there that they were claiming they lost their property because of the Torrens dispute. But where was the wrongdoing as the error, mistake, or misdescription? Who caused that? Was it by someone working in a statutory capacity, or was it the other party? So without knowing that detail, that's footnote 3. There it is, Minnesota, 1994. Zaradka versus State, Office of the Treasurer. Okay. Let's continue here. It has been stated that an assurance fund under a Torrens Act is similar in effect to an insurance contract between a certificate holder and the state as holder of a certain fund. 1937. So this is definitely for the redress, because if there's no way for redress, then that's just meaningless words on a document. Our First Amendment right for redress has to be preserved through these statutes. An employee responsible for handling Torrens registrations can be found criminally liable, such as where payments are received and accepted in excess of those authorized by state law for Torrens filings. Wow. Imagine that. And we're on to Section 10 now. The effect of fraud in registration of land title. Certificates of title procured through fraud are generally null and void. Fraud sufficient to reopen the status of a registered title in the hands of the original registrant may include constructive fraud, such as registration secured upon statements contrary to fact, which were susceptible of accurate knowledge, and which were recklessly made by the registrant. The integrity of certificates of title must be scrupulously observed, and every subsequent purchaser of registered land who takes a certificate of title for value, except in cases of fraud to which he or she is a party, is entitled to hold the same free from all encumbrances, except those noted on the certificate and the statutory encumbrances enumerated. The remedy available to an abutter who objects to the establishment of an easement adversely affecting his or her land is to oppose the registration in land court, or to file a challenge to the decree on the basis of fraud. All right. And we have our cases there, 94, 86, 93, and 92. All right. At that, we're going to be leaving off on this one. We'll take up next time on Section 11 when we'll go over procedure for registration of land titles generally and the nature of proceeding. And that gets on to our practice and procedure part. So that will be an exciting one if you're interested in finding out more about the titles and the Torrens Act. So I'd like to thank everyone for coming by tonight. It's been a interesting journey down this Torrens title system here and finding out the statutory reasons for having these registrations of land titles, keeping properties marketable, and to keep a public way of having an easy way of viewing any encumbrances that might appear currently or later on a property that might be undisclosed. And let's face it, it's originally intended to keep honest people honest. And the only way it's going to do that is if honest people participate within the remedies and such that are, again, constructed within it. So by knowing this, it protects us whenever we're involved with these kind of transactions, because as it's gone on through the years, and especially since the 1950s, the registration of land has really taken over a lot of the legal aspects of land ownership. And it behooves everyone to be familiar with that system, whether they're working with it through, the abstract titles or the Torrens system. So on that, I'd like to thank everyone for tuning in, and I hope to see you all on the next one. Peace out.